Ryan, can you go on camera, please?
And we are.
Very good. Thank you.
Of course. You can hear me well?
Can hear you well. Thank
Okay.
you.
Hi, Shelley.
Hi, Tom.
How are you?
Good.
How many board 1, 2, 3, 4, 5, 6? 5.
5. We're missing, looks like we're missing Aaron, so hold on just a moment. Looks like everybody's here.
Okay. All right, so we have 5 board members, 6, 1, 2, counting me. 1, 2, 3, 4, 5, 6 present. All right. I will call the Board of Adjustments and Appeals meeting to order for Wednesday, May 10th, 2023. Ms. Warwick, can you please take the roll?
Mr. Rieger,
Present.
Ms. Schmitz, can't hear you. Mr. Friesen, Mr. Thompson,
Present.
Mr. Collins,
Present.
Chair Finn.
And I am also present. So we need approval of the meeting minutes from April 12th, 2023. There are 1, 2, 3, 4 folks that were present, I believe, so we can vote. 1, 2. I'm having a problem with math tonight. 1, 2, 3, 4 people present, so we can vote on them. For the folks that were here, Mr. Collins and Ms. Schmidt will abstain since you guys were not here. So we'll do the approval of minutes from April 12th, 2023 by a voice vote. All those that can vote and are in favor say aye. Aye. Any opposed? No opposed. So approval
We
of
need
minute.
we need a first and a second, please.
Oh, I do need a, see, I need a motion.
Yes,
Move to
please.
approve the minutes for the Board of Adjustment and Appeals for April 12th, 2023.
Perfect.
Second.
Perfect. We have a motion and a second. Now we will do the vote. For all those present and not abstaining. All in favor say aye.
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 Aye. Any opposed? None opposed. So approval of minutes. I need a approval of finding a fact.
Tom, we don't have any.
We
finding
don't
of-
have a finding of fact? Oh,
No.
because we didn't have a, I thought we had,
We had a waiver and a continuance.
okay, so we don't need,
There is-
okay, perfect. Oh, awesome. Okay, well, then, we will jump to the case. So there are 5 members, 6 members present. Therefore, 5 affirmative votes are required to grant a variance or appeal. The board is authorized to grant or deny variance by Part 3, Section 60 of the Englewood City Charter. Anyone aggrieved by a decision rendered by this board may appeal that decision to a court of record. However, such appeal must be made within 30 days of the board's decision. Any approved variance is effective at the end of the appeal period. Building permits for construction associated with improved variance will not be issued until the appeal period is ended. Building permits must be obtained and construction began with 180 days of the variance's effective date. Procedure for the meeting is that the case will be introduced. An overview will be given by staff. Applicant will present their request and reasons the variance should be granted. Proponents will be given an opportunity to speak. Opponents will address the board if present, and if needed, staff will again address the board. So this is the public hearing for case number VAR2023-003, and it's continued from April 12th, 2023 meeting. And so we have 2 cases, real quick to review. 2 cases, there's going to be, they'll both be presented, but we have 2 different set of variances in front of us. So the first one, first variance is 2023-003, and that's the continuation from the April 12th, 2023 meeting. The applicant is Dokken. Property is 2820 South Lafayette, and this is a variance to encroach approximately 5 feet, 5 inches into the required 7-foot minimum side setback to convert an existing structure into a residence in the R1A zone district. The applicant is also requesting a variance to exceed the maximum allowed residential front yard 1/3 of the depth by the lot, approximately 32 feet. Then there's also case, and I'm assuming that we can hear these both at the same time since they're related and they'll deal with the same facts. We have case VAR2023-005. This is the new one in front of us. The applicant is also Dokken again. It has to do with the same property at 2820 South Lafayette. The request for this is the applicant is requesting a variance to encroach approximately 7 feet 8 inches horizontally into the required bulk plane to convert an existing structure into a residence in the R1A zone district. So we will have staff present on both of these. We will talk to staff, we will talk to the applicant, and then once we get to the 2 motions, we'll do 1 motion, a discussion, we'll do the second motion, we'll do 1 motion, discussion, vote, then we'll do the second motion, discussion, vote. And I think that'll wrap stuff up. We do have verification of publication and posting of the subject property that was sent out. Staff, if you could give us an overview.
Ryan, I'll go ahead and swear you in if you can raise your right hand. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name.
Ryan Daniel Herring, Planner 1. All right. Good evening, board members and applicant. So this is the first. You'll see 2 presentations that will sound suspiciously similar, but let's get started with our first one. Property and zoning location. This property is located in the northeastern portion of the city in the Kimball Croft Park Amendment Number 1 subdivision. Property and all surrounding properties are located in the R1A zoning district. There are no previous variances associated with this property. And now for some background. The property came in with Kimball Croft Park to the city in 1950. This created 3 lots on this corner of Bates and Lafayette. Now the amendment there was an amendment to the subdivision in 2016 that created sewer and utility easements. So then we set ourselves to finding the building dates of each of these properties so we could find a relative, what they are to each other relatively. 2800 South Lafayette is the oldest primary structure at 1941. 1410 East Amherst, which is to the east of the property, was built in 1957. And lastly, 2820 doesn't have a building construction information associated with it available at municipal and county records. I haven't shared a screen. I have presentation to share, so for you to follow along. We see it, and we will go full screen. All good now? We see? Yes, all right. Project location overview. We've gone over what the requests are. Here's an aerial for our reference, and feel free to refer back to these. Now for analysis. We'll go through these graphics again to refer to later at your will. First criterion is that unique physical conditions exist. Now, as a corner lot and in the R1A district, this lot is actually kind of large for the R1A even, but despite that space and the size, the structure is set so far to the rear and north side of the property line that it creates difficulties to meet R1A setback, lot coverage, bulk plane requirements, if the structure is to maintain as a principle. Second, the variance is consistent with the intent of the zone district, and granting these variances would bring the property into compliance with the R1A district dimensional requirements and enable the owners to apply for a building permit towards renovating the structure for use as a single unit dwelling, which is the base use for this district. Third criterion is that the variance will not permanently impair or the use of development to adjacent conforming properties. These variances or determination do not impair adjacent conforming properties or alter essential neighborhood character. Fourth criterion is that the variance is not a self-imposed difficulty or hardship. Now, it was incorporated in 1950 as we, incorporated in the past, as we mentioned, the structure's original construction, the Kimballcroft subdivision amendment, and the addressing request were all conducted by previous owners. So the current owner's request for these variances represents an acknowledgement of the property's existing nonconformities and a good faith intention to bring the property into compliance. For these reasons, the Community Development Department recommends that variances be approved for the above stated reasons. We've received 2 letters in support and 1 letter in opposition. I'm looking through your packets and I do not see why the letter of opposition wasn't uploaded. I can read and refer to it if you want, but this one, the opposition is from 2800 Lafayette, and the green arrows, diamonds denote the in favor. And because it's not in front of you, I will read what the neighbor notification objection is coming from 2800 South Lafayette. We heavily oppose the city's of Inglewood's stance of converting this, I apologize, I can't read the next word, structure to be torn down and should be grandfathered in or labeled as a historic property. So I think the comments may have not be pertaining to exactly everything that's going on, but it's important to know that we've received this. That concludes my presentation. Thank you.
So, Mr. Herring, the opposition letter seems to state that they oppose Inglewood tearing down the structure.
It seemed to be that's the stance. We heavily oppose the city of Inglewood's stance of converting this, next word is unlegible, and structure to be torn down. Period. It should be grandfathered in or labeled as a historic property. I think, unfortunately, the writer might not have had all the pertinent facts, but I understand the will and desire to label as historic property and preserve. The sense I think that I get is a sense of trying to preserve the property rather than tearing it down. So I think that perhaps this person was under the impression that something else was happening.
And Mr. Herring, so I believe that this, if we could go to the overview of the property.
The aerial or the
aerial. So if you could go back over on, so the lot in question is the one that's outlined in
highlighted,
yellow.
yes, in yellow
but
dashed lines.
It used to be part of the lot above and below it.
Above and to the right or the east.
Okay.
So my area, these 3.
So this used to be all one lot
That was all one.
subdivided.
That's right.
Two of the houses were, do we know if this barn was, for the lack of a better word, barn right now? So do we know which house this structure belonged to previously?
I have a sense, or it's arguable that it belonged to 2800 because the address request came from the owner of 2800, I believe, back in 2007. And that's the main clue for me, is where the address request came from. That's if my memory serves.
Okay,
A previous owner. So I believe that what happened was after that split in the 1950, after Kimball-Croft Amendment #1, which created the utility easement and actually kind of adjusted the interior lines. They were slanted a little bit. At that time, I think the barn per se was still was still in use, or to that 2800 to the north, or at least it was accessory, or it was owned by someone who didn't just own that one piece of property. And after it was addressed, then it was sold off, I believe. That's the narrative that I have. It was over the course of decades, these were parceled out, and then in the past decade, the address was assigned to this structure and then sold off.
I have a quick question as well then in that case. If it went, but prior to being sold, when it was a single lot, was an accessory structure, code wise, did it change to a primary structure when the parcel was sold, or did it stay as an accessory structure?
No, sir. No, that is the subdividing of land will not affect the designation of a building, of a unit. It is, and here's the stickiness. You can't, you shouldn't, you won't have a primary structure without, or accessory without a primary. This is a little zoning paradox here. Yeah, you're right. But it does not magically become primary because it's the only structure on there.
Okay, so it's kind of in a limbo state of structure.
Right. Exactly. We kind of have this is the time and place to have that, what is it exactly? It's been casually considered something, and now we do officially consider it something.
Okay. And that kind of leads me to a second question, which I don't know if we'll need the city attorney on, but I know as far as self-imposed hardship, do we have an exact legal definition of what that means, or is it under the interpretation of the board?
Yeah, that might be above my pay grade. I'll defer to Brian, but as far as go ahead.
I've got Mr. Isom, the planning manager, on. If he raised his hand, I wanted to see if he wanted to speak.
Do we have to swear, man?
Ryan, can you
Yeah.
hear me?
Yes. Oh.
Sorry, I'm trying to work in our community room with some citizens. Is our attorney on the line?
He is. Let me get him. There he is. Can you hear us?
Yes, can you hear me?
Yes.
Yeah, I can just repeat the question. So as far as the self-imposed difficulty or hardship, do we have an exact legal definition as to what that means? Or is it up to the interpretation of the board? Oh, I think you're on mute. I believe you're on mute.
I can look into that. When I review the materials for this board, I don't actually recall seeing a definition for that, but I can take a look right now.
Okay, and I'll share my reasoning as we get to discussion. I just wanted to clarify that on the front end. Thank you.
Yeah, I'll have an answer.
I will say in the code for criteria considering zoning variance, it simply says the variance is not self-imposed difficulty or hardship. But yes, I would like to understand the desire for a clear definition.
So staff, I have a question for you. If we grant this variance and it's the intent of Mr. Dokken to have this be a residence, can at some point in the future, could this become an accessory structure if he builds, or an ADU? I don't know if their ADUs are allowed in here, if he tries to build something in front.
Am I unmuted? Am I still heard? Yes.
Yes.
Okay. It's a good what if question because to me it comes down to design. It's possible with good design. You know what? And again, maybe I have to tag in Brian. I'm sorry, it's a solid maybe off the top of my head. Brian, can you be more clear on it? I think it really comes down to you're not permanently signing this principal structure necessarily. This could be maybe. Well,
Got it.
So yeah,
Brian.
so yeah, we need to get Brian sworn in real quick.
Do you swear or affirm under penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name.
Brian Eisen. So right now, that is something that is still completely up for discussion as far as ADUs and whether or not they might be allowed in the R18 zoning district with the code next update. Again, the code next update is ongoing. The ADU discussion is ongoing. We are taking some comments back to the UDC steering committee next Tuesday night on the topic, this exact topic. I don't know that even if it was allowed in the district, I don't know whether or not this would meet the allowances for square footage. I think based on our current requirements, and again, it's not allowed in this district, but the current requirements for an ADU are much smaller than that existing structure. So it's most likely they would not qualify. And that if they chose to turn it into an ADU, they would likely have to come back before this board and request some other kind of variance. If this variance is approved, it's turned into a residential structure. Code next is approved, and then so there's about 10 steps in between here and there to get to for that to happen. So
Then one other question, just to make sure I'm thinking of the building the correct way. The front setback on this, would that be the west facing setback or the east face, the west side of the building or the east side of the building?
West facing South Lafayette.
Okay, facing the road. Okay.
The long that long gap of front yard is part of the problem, quote unquote.
Okay, but that would be the front setback you're referring to. Okay,
Right.
thank you.
So do we have a good diagram of, it looks like the bulk plane is 7 feet.
You want to maybe hold off on that one right now?
I think we can discuss it with staff now. We'll break them up
Fair enough.
for our motions, but I think that I would rather have this also discussed with staff while we're here.
Understood.
So I have another question, or are we going to do a presentation on the bulk plan prior to questions? Or
Yes.
You want to start with questions?
we were asked by our deputy city attorney to give 2 separate presentations.
Okay, so
I'll have to discuss the bulk plane issue with the
okay,
separate.
so we can't combine them is what you're saying.
Correct.
Okay. So then so we're only discussing case VAR 2023-003
So-
Yeah, that was not shared with us because we were going last time that we could discuss them both at the same time. So we're only considering the first request.
I do have another question then. For the creation of an accessory structure like this one, is it subject to the same side setbacks if it was like a brand new accessory structure? It's like if I was going to build a garage tomorrow, is it subject to the same side setbacks that a like primary residence would be?
You wouldn't build a garage tomorrow. I wouldn't permit it because you have a non-conforming property. Sorry, I'm not exactly following. It's you're asking if it conforms to accessory setbacks standing as it is now?
Correct. That's what I was curious, is what the accessory setbacks are required to be now,
Gotcha.
and are they the same as like a primary structure?
Gotcha. I hate doing things off the top of my head. Give me 1 minute and let me confirm it. Just to be, I don't want to misquote. All right, an accessory. So when you say an accessory, you're saying a garage specific?
Yeah, let's start with, let's go with garage.
Okay, so in R1A, aside for the garage is a 5-foot setback. Now, I mean, I'm trying to follow what are you getting at?
I mean, thought process wise, I would be concerned if we said, a precedent was set of, oh, hey, I built a barn and then sell the property. If it's already existing over there, then, oh, hey, it's probably going to get grandfathered in. I'm just thinking kind of the potential long-term implications.
Gotcha.
Do we have any other questions for staff at this point?
Yeah, what's the square footage of the existing structure?
I would refer to the plan, and it might maybe just be faster to hold that question for the applicant, because I would just be reading from the plan. Sorry, I don't have it off the top of my head.
That's fair. Thanks.
Any other questions for staff at this point? All right. I believe, Mr. Herring, we're momentarily done with you. If the applicant could come forward to testify in the case, and please state your name and address to the secretary who will administer the oath.
You raise your right hand, please. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes,
Please state your name and address.
J. Dokken, 2639 South St. Paul Street, Denver, Colorado, 80210.
Thank you, Mr. Dokken. So we have your packet. If you want to, can you address quickly the size of the current structure?
Yeah, so the main floor is 1,660 square feet. It has an upper kind of loft area that's 730 square feet.
And then do you know what year this was constructed? I don't know if that's been stated.
I think the early 1900s. I don't know of an exact date. So, and you guys were talking earlier about like which was the first house in there. As far as I know, this was the first structure in the whole kind of area, and it initially served an orchard that was around there before the subdivision got put in.
Are there any current, is it just 2 big rooms, a big floor plan inside?
Yeah, so there's kind of a garage area, and then, yes, it's an open floor plan. There is a partition in the back. And then like a powder room, I guess, that one of the previous owners put in.
Does the board have any questions for Mr. Dokken?
Yeah, I have one. Was the property purchased with the sole intent of converting that structure into a residence?
So it has evolved. I think the property was purchased with the intention of saving the structure itself. Throughout the course of digging into this, the only way to kind of save it is to, or the only way to, for us to make it work for us and our needs is to convert it to residential.
Okay, and then I assumed in that case, the reason that a different proposal that would fit within the current code wasn't considered is because it would involve tearing down that structure. Is that correct?
That's correct.
Does the board have any other questions for Mr. Dokken?
I've got a question about if we were to add some sort of contingency on this variance that specified that it would only apply to this existing structure and not to a different structure if it were to replace it, would that be acceptable?
Are you asking me or yeah. That's fine. I would assume that if you were to tear it down and build another structure, that you would have to go through the same process to get a variance. So yeah, that's fine with me.
Thanks.
Any other questions for Mr. Dokken from the board? All right, Mr. Dokken, I believe we're through with you for this first case.
That sounds good.
Perfect. Are there any people present who wish to speak in favor of this request?
We've got people online and in person, so I think I'll just call on everybody.
Okay, so we'll just have them speak for or against all at one stroke. How about that?
That sounds good, and we'll start, I can start online or in the community room, whatever you prefer, or.
I will leave that up to you.
Okay. I'm going to start online, and I've got a caller ending in 691. Did you wish to speak regarding this variance case? Got a caller ending in 691 online.
It appears that person's on mute.
691 I just saw came off mute, but I think then they
Okay.
dropped.
They dropped.
Up their back, but now they're off mute.
There we go. Caller ending in 691. Did you want to speak regarding this variance case?
Yes.
I just need, I'm not sure if I can get you on camera.
No, because she's on, they're on a phone, so you'll have to
Yeah,
just
that's
verbally.
true. Yeah, sorry about that. If I can get you to swear in, and I'll get your name and address.
Vicki Hoffman, 7428 South Ogden Way.
Okay, Vicki, do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and
Yes.
Appeals? Thank
Yes, I
you.
do.
Hi, Ms. Hoffman, if you could just
I-
speak, if you could tell us what's on your mind, speak for or against this.
I'm against this. from what I can tell is there used to be a house on that property, that I just pulled up. And at 2820 South Lafayette, I'd like to know where the house went. The developer, or builder, bought it in October of 22 for 400,000, and there's no house. And I'd like to know where the house is, A. B, once again, the poor people of Englewood are having to deal with another massive structure that is, potentially being looked at. And, based on all of the circumstances within Englewood right now, I believe that, my friends and acquaintances have had enough of these large structures, and that this does not serve the purpose other than to line the pockets of the developer and his brother, who's also on this paperwork, is the real estate agent. So I am definitely against this. Thank you.
Thank you, Ms. Hoffman.
I have a Miss Mitchell. Did you want to speak regarding this variance case?
Yes, can you guys hear me?
Yes, we can.
We are 2800 South Lafayette.
Wait, I'm sorry, the Mitchell, we need to get
Mitchell,
you
can we
sworn in
swear you
first.
in?
Perfect.
Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
I do. Is name and address, please?
Evan Mitchell, 2800 South Lafayette Street, Inglewood, Colorado, 80113.
Thank you.
Thank you, Mr. Mitchell. If you could state if you're for or against this.
We
and
are
a brief
for.
reason. Okay.
The letter that we did write in, we are obviously misunderstood. And Ty and Jay are free to do what they want. And we are for this. So I just want to set the record straight.
Perfect. Thank you. Thank you,
Thank you.
Mr. Mitchell.
No,
All
I've got
right.
I've got more on the. Miss Kristen, Peg Kristen, did you want to speak regarding this variance case?
Yes, hi.
Let me swear you in, Peg. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes.
Can you please state your name and address?
Peg Kristen, 1410 East Amherst Avenue, Englewood. We're the property directly east of the structure. And I did fill out one of the forms, but it didn't make it to you all, I guess, in time. We are in favor of the proposal, but we would suggest that the board make it contingent. The variance is contingent on the existing structure, so that if in the future the barn is torn down and a new structure is placed on that property, that we feel that any new structure should conform to existing setbacks to make it fit with the neighborhood. We like the character of the barn, but we don't want a new structure set that far back because it's basically across the driveway from our property.
Okay, perfect. Thank you, Ms. Christian. I appreciate it.
Mm-hmm.
I've got a Ty. Ty, did you want to speak regarding this variance case?
Hi, Ty Dokken. Hi, everyone. I don't think so. I think everyone's got it handled, but our main intention was.
Yep. Hold on, Ty.
Yeah,
if you're going to speak, yep, we need you to swear in if you're going to have
Okay.
comments.
I'll give a comment.
Do you swear or affirm under the penalties of perjury that you would tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name and address.
Ty Dokken, 4705 South Clayton Court in Inglewood, 80113.
Perfect, Ms. Dokken, and you're free to make your comment.
Yeah, I mean, our original intent was to use it as is. And I feel like we are kind of forced into turning it into R1. So it's not our main choice to do that, I think. But we're okay with it. We understand it. We knew the zoning before of what it was zoned but weren't sure on being grandfathered into whatever it was, but we're okay with changing it to R1, right? Residential. And we too liked the charm of it. And we've always wanted to keep the look and feel of it. And so hopefully we can get it done.
Perfect. Thank you, Mr. Dokken.
Oh, and sorry, one other comment. We're not doing this to make money, by the way, whoever said that. You know, this is if it was to make money, we would scrape the structure and build a house for today's family. So we're trying hard and we're spending extra money to keep it as is.
Perfect. Thank you, Mr. Dokken.
Thank you.
Okay, Jan, did you want to speak regarding this variance case?
Sure, I'll speak quickly.
Jan,
And-
let me swear you in. Hold on. Do you
Thank you.
swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name and address.
Jan Weipert, 3087 West Grand Avenue, Inglewood, Colorado 80110.
Ms. Wiper, if you could give us your comments.
Okay, one of the things and one of the reasons I got on here tonight is because Inglewood keeps making adjustments to properties and allowing things to be built, changing bulk planes, making things uncomfortable for people that live close. And so I would like to say this. I have not studied the plan, but I do believe that if there are changes made, that they should be for this property only. And if they do additional construction, that those need to go through the appeals board to make any future changes. And I like what Vicki Hoffman said. Nobody here seemed to know there was a house that's got scraped at some point before or after these folks bought it. I don't know, but it seems like there are some mysteries that would have been nice to have known about as this came in front of the board. That's all.
Thank you, Ms. Wiper.
Thank you.
Okay, we're going to go to the community room.
Hi, Shelley. We've got 3 folks present. Does anybody want to speak first? Make sure the camera is good.
Okay, I'll go ahead and swear you in. If you can raise your right hand, do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name and address.
Kathleen Bailey, 4686 South Jason Street.
Hi, Ms. Bailey, if you could give us your reasons for or against this.
Yes, good evening, Chair and board members. I am here tonight as an alarmed and very concerned R1A resident to ask that you please deny this variance 2023-005 that is before you tonight. This applicant seeks for you to approve 3 significant precedent-setting variances based solely on a desire by the applicant to develop an existing outbuilding. There is no existing barrier or impediment to his building a residential home elsewhere on the 11,730 square foot property. And based solely on his desire to use this existing outbuilding on the back of the lot, he is seeking a variance to allow an encroachment of 7 feet 8 inches vertically into the bulk plane, a variance to allow an encroachment of 5 feet 6.5 inches into the minimum 7-foot side yard setback, leaving only a 1 foot 5.5 inch side yard, and a variance to allow a 32-foot encroachment into the maximum front yard setback. And I also want to express my alarm and concern that community development brought this case forward with the recommendation for approval, despite easy options for the owner, and opposition from a neighbor directly north who will experience direct impact by the development to the residential, to this residence through those 3 significant variances. As the client admitted on 4/12/23, he could very easily scrape the outbuilding and build a residence elsewhere on the property with full compliance of all existing Title 16 laws applicable to R1A. And again tonight, the developer indicated they could easily make a standard residential property on this site. One of the reasons this client expressed as to wanting, last meeting, as to wanting to keep the existing outbuilding was the plank floors. But I have no doubt he could reclaim the outbuilding wood floors he admired and use them in his new structure elsewhere on the lot. I am not clear whether the existing structure would prohibit building a residential structure on the site with the existing outbuilding remaining as an outbuilding on that property. It is a huge lot. If variance 2023-004 is approved, this would set an alarming and significant precedent to the use of this Board of Adjustment and Appeals by both applicants and community development as a means to simply avoid existing law by seeking multiple variances to build a desired structure without any concern for impact on neighbors. And as a preemptive action, and possibly as a preemptive action in anticipation of hoping to get approval for ADUs in the future and developing the remaining large front yard with another structure in the future. I ask that you please deny this case. But I know you will do the best you can to serve all parties. But I thank you for your time and consideration.
Thank you, Ms. Bailey.
Hello.
Hi, if you could raise your right hand, I'll go and swear you in. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name and address.
It's Marcy Brown, 2980 South Sherman Street, Inglewood.
Hi,
Okay,
Ms. Brown, if you could state if you're for or against this and a brief, any brief comments.
okay, yeah, I am opposing these variances. I think that if the board allows these variances with the setbacks in the front yard, I think it sets a very dangerous precedent about what could come on down the line here. As you know, board members, Code Next is a big deal here in the city. And if Mr. Dokken, both of them, if they are from Denver, they are developers, and I doubt very much, and please correct me if I'm wrong, if they are going to move into this property. I would imagine that they're going to build this and then sell it for over $1 million or up to $1 million. We are trying to get affordable housing into our city. This is not going to work. And I would just ask that the board also consider the setbacks. You know, they're going to be 2.5 feet. For me, that's not enough room for privacy. And I also believe it's a fire hazard. So I would ask you to please deny these variances. And I also believe that they could have built something much more suitable to that community and to that neighborhood. So thank you.
Thank you, Ms. Brown.
We have one more.
Okay.
Good evening.
Good evening. If you could please raise your right hand, I'll swear you in. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes,
Please state your name and address.
it's Aaron Reed, 3584 South Corona Street, Inglewood, Colorado, 80113.
Mr. Reed,
So-
if you could, if you could give us your comments briefly.
Yeah, I happened to come home by this sign the other day. It was kind of bittersweet that I would take that route for something totally unrelated to this, but here we are. And then I saw it and I was like, okay, why would they need a variance for this building? And then, of course, that's when I started reading the sign. As many of you are aware, this is not going to work on the computer screen because it barely works with my Hawkeyes. I am referring to the city zoning map, updated in 2016. I realize there's newer revisions, probably on everybody's desk except for mine right now. But with that said, I do understand that this is to be an R1A situation right here. And I see the house and where it is now. And as many are aware, including anybody that's bought a property, including this property, 7 foot is a setback in R1. And if they go 5'7" into that, that leaves less than 2'5". In R4, the minimum setback's 3 foot. So this can't be approved. I would be totally against it. It's not allowed in the most dense of situations, including my zoning in this city. So PUDs have minimum setbacks on sides for 3 foot, and that's inadequate. This can't be allowed. This would set a precedent where everything would be willy-nilly variance hearing, board adjustment hearings, and it would also set a precedent where a building that I was supposed to help on here in 2020 prior to COVID years, where the variance was only requesting 3.5 feet into the bulk plane. And that was in MU2B. So, excuse me, R2B, I stand corrected. And that wasn't allowed and was voted on at that board at that time, nearly unanimously no. So this would open the door for that project to go with flying colors, because it was half the ask of this. Now, as far as the front yard landscaping, it seems to me you could chop off the left-hand side of the house as you're facing it from the street side, move it in 4 feet, get your 7 foot back, and then encroach because of the trapezoid shape of the yard. So surprised that hasn't been thought of. That would probably be approved under normal circumstances as the bulk plane and stuff allows, and just the side setbacks and forward and back setbacks. This is everybody's seen this before. And I have to believe that if the bulk plane was on a very sloped lot, like the one I was potentially going to work on in 2020, that this could be an undue and the term we used earlier that everybody's used, a burden. So this is hardly a burden. I can't see the elevation change, even though this is trapezoid from front, left, right to back to rear at the site triangle, with the prior photo up here being more than 3 foot in deviance. So this can't go through as requested like this. There has to be no way that this goes through. It's an extremely tall ask. It would not go through in R2 as prior history that I've experienced. So it definitely shall not happen in R1. Thank you for your time.
Thank you, Mr. Reed.
That looks like that's everybody.
All right.
Yep.
Thank you, Shelley.
Thank you.
Staff, Do you have any additional comments?
I'll keep it brief. I think it would be helpful for me to reiterate that this is not about new construction. The variances refer to the structure as it is. The variances allow for the structure to exist. As it is right now, it's nothing to me. It is wood, concrete, and metal. It cannot be used for anything. It is R1A. We're not changing zoning. We're not redesignating zoning. It is in R1A. It has been in R1A as long as it's been in the city. It's only ever qualified for residential use. Now, granting the variances, I've heard the word precedent. I won't necessarily go there. Every variance is considered on its own merits. They're not that's enough that I'll say right there. Other than that, there's a lot to kind of remember, but I think those are important details. I want to reiterate that the variances refer to the structure that is already on there, which I uncovered no evidence of another structure, another house
Right.
being on this property.
So Mr. Herring, we have no indication that the house that this was the barn of was
I was
on
not
this
able to
lot?
find it. If someone can provide me where the evidence of another one was, I'm open to it.
Yeah, I went back to 2007, just looking at Google Maps, and it doesn't appear that as far back as then there was another structure there.
Right.
And then also, Mr. Harrison, so in order for a structure to conform to all the variances on this lot and to build a home that the owner would have every right to build, in essence, he would have to scrape this building and then conform to the variance, but he could still build a fairly big structure, could he not?
Right, conceivably. And again, that is another thing to note is that variances carry with the land traditionally unless you otherwise specify. So that's an important thing a lot of people have raised. If you just say, here's a variance, it's on the land, and 30 years from now, when we look at it, they'll just say, hey, we have a variance here. So if you want to specify that this has conditions and stipulations, now's the time to do it.
Does the board?
Tommy went on mute.
Does the board have any other questions for staff at this point?
Yeah, I just want to make sure I'm reading this correctly. Even if there were to be a principal house on this structure or on this lot, it would still be a non-conforming accessory structure because of its size. Is that correct?
Right. The things that are non-conforming are its proximity to the structure to the north. Right. Exactly.
Right, and even its square footage would be too large.
Exactly. So yeah, you would maybe have to reconsider something here and there, but yes, these are all physical related variances.
Thanks.
So if you were, again, if you're changing the context, saying if this is something else now, yeah, that does change the math. Yes, that does change the situation and changes the answer, but we have this context now.
Any other questions for staff at this point?
I had just a clarification for Mr. Dokken. When we've got
All right. Yep. So we'll bring so Mr. Dokken. We have one more. So Mr. Collins, you wanted to ask Mr. Dokken?
To confirm something I heard him say earlier. I just wanted to confirm that you said you would be comfortable if we made the variance specific to the existing exterior structure as it exists today, correct?
Yeah, I'm fine with that. I mean, obviously, anything that kind of limits your options in the future, could be a bad thing, but I'm fine with that. And I actually assumed that if we were to build anything else on there, it would have to adhere to current zoning and building regulations.
Perfect. That's what I wanted to clarify. Thank you very much.
Yeah.
Staff, did you have another comment?
Yeah, I think I would reiterate that from another direction because it was a common concern that that there would be some large bulking addition or something. That what we're granting here is to the existing structure for it to be operable as it is as a residence. If not granted, then you get who knows what. Then if you don't get this variance, then the owner has to come up with a new solution, and that's the possibility of where you can get something that conforms to code.
That does bring up another question for staff. If we made the variance specific to the existing structure in its current state, would that mean that any addition added, even if it's not within a setback, would create a conflict with that variance?
An addition could conceivably be made, but I would put it on the side of the building that doesn't have anything to do with one of these variances. So yeah, you could, you know, my answer is always, it comes down to design. Yeah, it's possible if you show me the plan, the paper. Yes, I can see it. I can see a world where, you know, there's some expansion here or there without a variance, maybe, but I need context. Thank you. Yeah, I get what you're saying.
Yeah, I just wanted to make sure if we chose to amend the current motion to make it specific to the existing structure, and you were to add an addition that's a change to the existing structures, would that create an issue there on the zoning, on the setback? Would that, because that addition would change the current structure, which would go in violation of that. I'm just trying to think through how we would do that.
Yeah, so we can, oh, go ahead, Steph, and we can also have a discussion about this once we.
No, actually, I was going to call on Brian again because I think I need a little more experience to answer that one.
You're on mute, Brian.
So if you were to approve it with a condition that it's based on the current structure, current state site plan that was submitted, they could potentially do additions, but only in areas that don't encroach into any setbacks as long as they meet 100% of our code. If they chose to add some kind of addition that would encroach in any way, shape, or form anywhere else, we'd be right back here going through the same process.
Perfect, thank you.
All right, any other questions from the board for staff or the applicant? All right, so the public hearing is now closed. So this is for the first case. I need a motion.
I'll make a motion to approve case VAR 2023-003 to approve a variance to encroach 5 feet 5 inches into the required 7-foot minimum side setback and to exceed the maximum allowed residential front yard of 1/3 the depth of the lot by 32 feet, contingent on the variances only applying to the existing structure at 2820 South Lafayette Street, ceasing to be in effect if the existing structure is demolished. These are variances to table 16-6-1.1, the summary of dimensional requirements for principal structures, and section 16-6-1F.1, maximum residential front yard of the Englewood Municipal Code.
Second.
All right, discussion. By the way, Mr. Taylor, that was a nicely formed motion.
I had to write it down.
Hey, can
I'll
you
admit
guys
that.
hear me now?
Yes, yeah, Ms. Schmitz, we can hear you now.
Okay, good.
So before the board continues, I just wanted to interject and answer
Wait,
Mr. Cox.
I think, oh yeah, go ahead. The definition?
Yes, I looked in code, bylaws, and any other sources that I had, and I was not able to find definitions for the criteria.
No, there aren't any.
Discussion, what do we think?
On the slippery slope or precedent issue, if we get another case where there's only an outbuilding at the rear of the lot in the R1A district where they want, anyway, if we get another one like this, I'll fall over. And
that was built in 1900.
So yeah, this is as unique as it gets in my view, and we look at the whole picture. It's not like if this thing has, is 1 foot from the side lot line, that in every case we're letting things be 1 foot from the side lot line. That's not how we look at things, just to kind of address that concern.
Yeah, I'm also, I like how the neighbors around are the ones that submitted the letters in support, and that they're for it, and that it seems to me like they would enjoy having a little bit of history remain.
Yeah, I'd also say on my end, the building's already there. We're just essentially blessing it and to be a residence. And I think that's a lot better than just an empty structure sitting there. And if it's already there, it's already there.
Yeah, and in some respect, it's actually more controlled this way, because if the landowner has every right to come in and raise it, and then he could build a house that's a lot bigger than this one and max out the size. I'm somewhat encouraged whenever people are at least considering some of the history that's in the area to try to save it and reuse it, I think.
Yeah, the only way I could see for it to be saved is with a variance, because if the lot were to, a principal structure would be added to the lot, you couldn't have it with this non-conforming structure on there as well. And so there's no way to keep this building and add something else.
Yeah, correct. And I think, Mr. Collins, we've had the discussion about like self-imposed difficulty and hardship before, especially when someone buys a property and the building is like this. And we've struggled with some of them, but you know, ultimately for us and the discussion, it kind of comes down to the hardship. He didn't build the building where it was, even though he did buy the property.
And the way I look at it too, again, building's been there since 1900 and everything else is developed around it. Lots have been divided, lots have been changed. That thing has not changed in, let's say, 100 years. So I think that keeping that historical, and I don't want to use that term, but I've heard it thrown around a couple times, but it's obviously older. But yeah, in order to keep it, the only way we can do it is by granting the variances.
Yeah.
Yeah, and Tom, you hit on exactly kind of where my mind is going at the beginning, is buying the property with the purchase of doing, but with it being an R1A, the intent of the zone is a residence. So, I mean, there's really nothing more fitting for the zone than to actually let it be that.
Yeah, and yeah, no, that's exactly, and again, that it's something we've struggled with before, because and the argument of, well, I could buy a piece of property, build a barn, and then sell it and have someone else buy it. I think if they plan for a structure for 100 years, that's pretty good planning. I think if it's 5, that's a long game. I think 3 years we might catch on.
And that's why I had so many questions for staff, as I was just thinking, like, is that even possible to do, like, the setbacks?
You got to make staff earn their money. I'm a firm believer of that.
I think in the past we've thought, well, I have thought simply buying a property that might need a variance is not a self-imposed difficulty. My weird example of it is, like, I come to the board for a variance to build a taller than allowed fence because I want to stick the fence in a trough that I've dug in my front yard. I maybe somebody else has a better example. That's my vision of what it means.
Yeah. Any other discussion, or should we vote on this first one? No other discussion? All right, Ms. Warwick, if you could, let's vote.
Mr. Taylor?
I voted yes. The first criterion, there are unique physical conditions with the existing structure on the lot. And so that meets that criterion. The second criterion is that the variance is consistent with the intent of the zone district, that the intent of the zone district is for single family homes. And so this would still meet that definition and that criteria. The third criterion, that the variance will not permanently impair the use or development of adjacent conforming properties as an existing structure. The other properties are currently enjoying their existing uses and not impaired, and that the fourth criterion, that this is not a self-imposed difficulty or hardship. This is something that has been carried forward for quite a while and is not self-imposed.
Mr. Rieger?
I would add that I believe, based on the information presented, the location of the existing structure was really, frankly, defined when the initial property was subdivided in 1950. Due to the existing property being zoned R1A and allowing for single family residence, also enjoyed by neighboring parties. I believe the first criterion is met, and I voted yes for the reasons already.
Ms. Schmitz,
I voted yes for all those reasons stated.
Mr. Thompson,
I vote yes.
Mr. Collins,
I vote yes, and would add the surrounding neighbors even confirm that there wouldn't be any impact to them with the permanent impairment.
Chair Finn,
I voted yes for the reasons stated, and that this property fits the 4 criteria that we are to consider. And there's no precedent set that each property has its own uniqueness that we have to consider.
motion passes 6-0.
All right. So this case is closed, and we're going to go on to public hearing for case VAR 2023-005 for J. Dokken. The property is 2820 South Lafayette. The request is the applicant is requesting a variance to encroach approximately 7 feet 8 inches horizontally into the required bulk plane to convert an existing structure into a residence in the R1A zone district. We have the verification of the publication and posting that was sent out earlier. Staff, if you could give us an overview, and you need to be sworn in again since this is a new case, I believe.
Yes. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name.
Ryan Daniel Herring. Let's share the screen one more time. And for the public's benefit, I will reiterate, this is on the same case. I apologize for confusion. This is a variance on, it's the same as a physical variance that regards bulk plane. The reason why we're having 2 different cases for them is because I didn't have enough information for the time of the last meeting to put it in and notice it. Now I have, would have wished to do it all at once, but it is the same nature of variance. All right, so the request is for approximate 7 foot 8 inch horizontal encroachment into the bulk plane to convert existing structure into residence. Located in Kimballcroft Park, amendment number 1. There are 2 variances associated with this parcel now from variance 2023-003. Background. We're seeing my screen now, right? I will jump down to the bulk plane graphic. All right, approximately 11,000 square foot parcel in the R1A came into the city in 1950. The property owner intends to convert the existing structure into single family residence, which is the reason for the variance. All right, analysis. First criterion, unique physical conditions. Parcel is large for an R1A, but despite the large size, difficulties are created due to the proximity to other structures, due to when they were built, creating difficulties meeting bulk plane requirements. Second criterion is that it's consistent with the intent of the zone district. Granting to this district would bring the property into compliance with R1 zone district dimensional requirements and enable owners to apply for the building permit towards renovations of the structure for a single use dwelling, which is the base use for the zone district. These variances, if granted, would not create any public health, safety, or welfare issues. The third criterion is that the variance will not permanently impair the use or development of adjacent conforming properties or alter the essential character of the neighborhood. Granting the variance would not impair the use or development or conforming properties. Fourth criterion is the variance is not a self-imposed hardship. They do not, we argue that they do not constitute a self-imposed hardship. However, the subject parcel was incorporated, the building's construction date could not be confirmed for the city through our records or the county records. However, the subject parcel was incorporated into the city in 1950 as part of the Kimballcroft subdivision. When the owners purchased the property in 2022. Graphic of the bulk plane is showed here. Now, for those of you who might need a refresher, this is an imaginary envelope, okay? You go to your side setback and you come up to your building height, and then you can kilter in at a 45-degree angle. And that line denotes the outer perimeter of the upper limits of your structure. This structure being built prior to the zoning code, built prior to being in the city, you can see why the encroachment exists. We have the calculations here. Any questions?
Does the board have any questions for staff at this point?
How confident are we in that bulk plan measure, or should we give it a little wiggle room if we were to consider this variance?
High confidence, because
Okay.
yeah. So where to begin? How much do we really want to know? Yes, so the measurements are off, we're taken from site plans, from the plans provided by the applicant. We've verified them, we've gone back and forth. We've edited this graphic, measured and remeasured. We're confident in the numbers.
Okay.
Any other questions for staff at this point? All right, Mr. Herring, I believe we're done with you for the time being. If the applicant could please come forward to testify in the case. Please state your name and address to the secretary who will administer the oath since this is a new case.
J. Dokken, 2639 South St. Paul Street, Denver, Colorado, 80210. Oh.
Shelley, you're on mute.
We all do that, don't we?
We do.
Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes, I do.
Thank you.
Thank you, Mr. Dokken. We have the packet which you've submitted. Would you like to add anything else before I open up you to questions from the board?
No.
All right. Any questions from the board about to Mr. Dokken? And Mr. Dokken, I assume that you would be okay with the variance written the same way that it applies to this structure and will not stand if the structure is demolished.
Yeah, I mean, honestly, I see this all rolled into one. I'm not quite sure why it wasn't kind of for legal reasons or your guys' process that it wasn't kind of rolled into one variance. So yeah.
Perfect. Thank you. Any questions from the board for Mr. Dokken at this point? All right, no questions. Thank you, Mr. Dokken.
Thank you.
If there's people who wish to speak in favor or opposition, please come forward. I'm going to hold these comments, any comments, to 2 minutes or less, and they can only be to the bulk plane issue because we've heard your other concerns. But if there's anyone who would like to speak to the bulk plane issue, please let us know.
I'll just have anybody online or in person raise your hand if you'd like to speak again.
Kelly, I think the folks in the community room would all like to speak again.
Okay.
Do you want to go through the way we did last time, or
we can do? Yeah, go ahead.
And can we go back to stop the screen sharing? Perfect.
I don't have anybody online who's raising their hand, so we'll start with the community room. And I'll need to swear you in again. New case. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name and address.
Kathleen Bailey, 4686 South Jason Street in Inglewood.
Thank you, Ms. Staley. If you could let us know your concerns, you have 2 minutes.
Yes, I actually have modified. I've sat before the Board of Appeals before, and I've also always been impressed and generally learned something when I listen to you guys, because your discussion is always very in-depth and very fascinating and personable, but very knowledgeable. I am less concerned about this development as a result of listening to you guys. And also I realized that when I read the third neighbor comment, what I focused on was we heavily oppose this. And I didn't really try to read the rest of it. I assumed it was heavily opposed due to impact. So that was my presumption. And listening to the dialogue on that, they were just concerned it was going to be torn down. One of the other things I was glad to hear and got educated concerning just by listening to you guys is I wondered why they couldn't keep this structure and put something up front. But that was clarified. Just keep the structure as is, as an outbuilding, and put a structure in total compliance elsewhere on the lot. But based on what I've heard, if I've heard it correctly, that could not work on this lot. It's a large lot, so I simply don't comprehend how that is not true, but I do believe what I heard. That is also reassuring. And the second thing that's reassuring to me, or the third thing, is that I do appreciate the idea that these adjustments have been made specific for this purpose. I hope that, because one of my fears, as I was using the word setting a precedence, that helps identify that this isn't precedent setting. This is specifically for this structure, and every separate thing that comes before you in the future will receive similar full consideration like you guys did. So I appreciate this board. I always have, and it's generally one of the few boards I still trust. So it was good to hear this. I may be the only one in my group who's can come away with any sort of a feeling pleased in this outcome, but I am definitely assured and less concerned. And I am cautiously optimistic that you will rarely do this sort of thing and usually be very concerned about making sure in all opportunity that existing laws be complied to first, because that benefits the rest of us. And as you know, R1A has been like a frog in a sandstorm with different things that have been approached to it by originally the city and then Polis. So I think we are a little bit hypersensitive, and this was one of the things I was suddenly caught and concerned about. So thank you for listening to me, and thank you for being so eloquent and clear in your comments. I've learned something, and I appreciate that.
Thank you, Ms. Staley, and we appreciate you.
Bailey, not Daly.
Bailey, and we appreciate you attending the meetings and giving your comments. We do consider everything we hear.
And I did hear that as well, and I have adjusted my concern rather than vice versa, and I appreciate you guys. So thank you.
Thank you.
We want to speak. Sure. We have one more.
Okay.
Oh, we have two more. Sorry.
Yep.
Again, raise your hand. I'll swear you in. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
Yes.
Please state your name and address.
Aaron Reed, 3584 South Corona Street, Inglewood 80113.
Perfect.
So,
And thank you, Mr. Reed. Again, I need to hold you to 2 minutes, please.
okay. The prior variance granted didn't take into account, as Mr. Dokken said, the bulk claim. With that in mind, that previous variance meeting I was referring to earlier in 2020 had a bulk claim adjustment request of less than half of this. at the 92-inch limit, and they were requesting 43, and it was denied. So this is double that, and it's an R1A. And I guess I'm just trying to get a handle on how this might go with it being such a tall ask, and how that one in 2020 went. And it was, I see a couple of you laughing, but 84 plus 8 inches is 92. So I'm glad you find it funny that the math is there, but it speaks for itself, whereas 3'7" is 43 inches. So if this happens, what are we as the public to believe is the new precedent, or is this just a one-off, or was the disposition of that hearing in 2020 different than this one, or is there unconcluded compassion and backroom deals taking place? I just want to know. Thank you.
So real quick, Mr. Reed, if I could ask you a question, in the case that you're referring to 2020, was that a new build or an existing build?
It was a new build, and it did not encroach into side, back, or front setbacks, and it was allowed to have an ADU, whereas here in R1A, as we all know, that's not allowed, at least not currently.
And that's not, we're not considering that, but
No.
Yeah, I just want to make sure that what's in front of us is this is an existing building, and if it's not granted, it'll be raised. So there is a difference of the two cases, and we don't set precedents. We take every case and we look at each case and the facts that it presents.
Sure, but I have to believe a person would know if they're in this residential 1A that they know they wouldn't have the 32-foot height or anything above 18 as it relates to this. So if they're using an 8-12 pitch roof, which the renderings didn't say, but it's assumed by the side setbacks and the bulk plane, unless there's some clarification on that, this is egregious towards other zoning districts as well as R1A, especially itself. Maybe that's not the case. Could you clarify?
We take every case with the facts presented. This is an existing building.
It's an existing building. What's the height going to be?
The height is currently set on the drawings. So it's within the bulk plan except for 7'8", sir.
And what are those?
It's part of the package.
Okay. Thank you.
Thank you, sir.
Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name and address.
Marcy Brown, 2980 South Sherman Street, Inglewood. I will use Aaron Reed's particular word, egregious, because that's what I find, that this is egregious regarding the bulk plane. And I'm very unhappy that all of you just went ahead and okayed those variances prior. I'm sorry, is someone laughing there? I thought I heard a laugh. I don't think this is funny if you are. It just seems to me, and I have been to BOA meetings before, that this board seems to bend over backwards for developers. And when residents want a variance, they have to jump through hoops. I was at that 2020 meeting with the BOA that Aaron Reed just spoke about. And boy, they picked apart every little thing. But of course, he's not a developer. But when there's a developer involved, it seems like you just push it on through. So that is all I have to say to the board.
Thank you, Ms. Brown.
I have somebody online. Jan, did you wish to speak regarding this variance case?
Please.
I'll go ahead and swear you in. Do you swear or affirm under the penalties of perjury that you will tell the truth in this proceeding before the Board of Adjustment and Appeals?
I do.
Please state your name and address.
Jan Wypert, 3087 West Grand Avenue in Inglewood, 80110.
Hi, Ms. Wypert. Yep, if you could briefly state your comments in 2 minutes.
Sure, I'll try hard. So one of my confusions is that I feel like the visual, what you're saying is happening is, it's been hard for me to look, and I did look before I got on here, what the changes are from what the building is now. And so I'm understanding that the first hearing did not change anything as far as the building itself, I believe. I don't know if I'm correct on that. And that
Yes.
now the bulk, I am correct on that. Thank you. And I wasn't clear on that. I thought you were increasing dimensions. Now, is the same true on the bulk plane, that those dimensions stay the same as the existing building?
Yes, ma'am. So
Thank
what's,
you.
yeah, what's in front of it, and I won't count this against your time, but what's in front of us is a building that's non-conforming. So in order for anything to be done to it, it has to have a variance, which means we have to grant the building in the condition that it is to say, okay, we're going to grant a variance for the position it's sitting in. If we don't, then what's going to happen is it can't be used as a residence and it'll probably be scraped.
Okay, thank you for that, because that was not clear either in the initial drawings from a uninformed person. I mean, I'm not a builder. I can look at dimensions and know what a square is, but it was not clear to me that that was what was happening. So I would like to say that I am concerned about variances being made generally. But I do feel like being able to go forward with this, as long as it's not increasing bulk plane, then I would say I would agree that it's nice to keep it in the neighborhood the way it is. So I appreciate that. Thank you for your service in our community.
Thank you, Ms. Wypert. Shelley, any other?
I'm gonna check with the phone call and then I think that's everybody. Caller ending in 691, did you want to speak regarding this variance case? I think
Me again. I'm
oh,
it came
I've
up.
got, yep. I've got it. 691, did you want to speak regarding the variance case? Okay. I guess not.
All right. Staff, do you have any additional comments at this time?
No. I'll apologize for not being clear that, yeah, this is about slices of the building that already exist. These are about conforming to the dimensions. The R1A has dimensional requirements that slice through the property invisibly, right? And the property that exists, the building that is there now, already encroaches on those minimal R1A setbacks and bulk planes. The variances allow for it to exist as it is. That's all.
And so, Ms. Herring, just to clarify that, so the variances virtually were not in place when this was built, and what we're guessing is the early 1900s. Is that correct?
It was right. It was built before it was in the city. It was built before the zoning. Yeah, exactly.
Perfect. Thank you. Does the board have any questions for staff? Any questions for the applicant? All right, the public hearing is now closed. Is there a motion on the floor?
I'll make a motion to approve case VAR 2023-005 to approve a variance to encroach 7 feet 8 inches horizontally into the required bulk plane to convert the existing structure into a residence in the R1A zone district, contingent on the variance only applying to the existing structure at 2820 South Lafayette Street, ceasing to be in effect if the existing structure is demolished, This is a variance to section 16-6-1.g, bulk plan requirements of the Inglewood Municipal Code.
Is there second? Mr. Collins seconded. Discussion. Anything? I mean, to me, the discussion lays along the same lines as the first.
Yep, agree completely. It's already there. We're just essentially giving it the blessing to be a house or a residence.
Yeah, I concur.
All right, are we ready to vote? All right, let's vote. Ms. Warwick?
I'm going to start with Mr. Collins.
I voted yes, because the unique physical conditions exist and that the structure already is there in its current shape and has been existing since the early 1900s. Intent of the zone is R1A is for primary single home residence, and that's exactly what they're trying to convert it into. There's no implication to public health, safety, or welfare, and it doesn't appear to permanently impair any residents around it, and they have come forward saying so as well.
Mr. Rieger,
I voted yes for the reasons stated.
Ms. Schmitz,
I vote yes for the reasons stated.
Mr. Thompson,
I vote yes for the reasons stated.
Mr. Taylor,
I voted yes for the reasons stated.
Chair Finn.
I voted yes, and I'd like to add with the second criteria, it's consistent with the intent of the zone district regulations. The third criteria, its variance will not permanently impair the use or development of adjacent conforming properties, and it's not a difficulty hardship.
Motion passes 6-0.
All right, that case is closed. Staff's choice. Do we have a case next week?
Month.
Next week.
Oh my God.
We better not. Okay.
Next month.
We
Do we have
do
a
not.
case? No case next month. City attorney.
Wait, we have, hold on, Tom. We need to, Brian's got some questions for you all.
Oh, okay.
The only item I have for staff's choice, I don't know if any of you are aware, but our Planning and Zoning Commission has been requested by City Council to return back to in-person meetings. So that's where we're at with that group. So we wanted to go ahead and pose the same question to this group as it was kind of given to us. I think originally that we would review every 6 months with our boards and commissions on whether they wanted to remain virtual or go back to in-person meetings. So since we had the Planning and Zoning Commission kind of sent back to in-person meetings, we wanted to reach back out to you all at this meeting and ask your thoughts on this board returning to in-person meetings.
Is planning and zoning doing hybrid or totally in person?
So we had a meeting this Tuesday in council chambers that was in person with kind of a hybrid approach. It was our first round at doing everything. So we were trying to ease the commission back into it a little bit. By the end of this month, it will be our intent is to go fully in person with the ability for hybrid for folks that may be ill or out of town, but not necessarily folks that don't want to necessarily drive in for the meeting. So the bulk of our commission, I think Tuesday night, all but one person, I believe, was in person out of the folks that attended the meeting.
I think it would help. I think it would help our public hearings go better. I mean, I think it just eases some of
Are
the.
you saying they're going bad?
Well, I think folks could see, you know,
See our sincerity and our
just the logistics. I think it just keeps it rolling a little easier.
I'm gonna have to wear pants. You understand?
I was gonna say the only challenge I would have is I usually have 2 or 3 screens up so I can kind of look at scroll through it at the same time. Because I mean, usually I'm scrolling through the presentation, like I've got that code up at the same time. So that'd be the only challenge I'd have.
Yeah.
And an umbrella.
Yeah, so I think the way we handle this is what I would prefer to do is send out an email to have everyone on it. And maybe we go to hybrid to start off with, and those that want to come in, and those that don't. But
I do have a question, Shelley. Wasn't part of the reason we didn't come back is because we didn't have space?
They were changing all of our technology.
Ah.
So we're learning the new technology in the council chambers. But, so that'll, something we'll have to learn all over again. But it ran really good on Tuesday for P and Z.
Okay.
And we are getting more requests. If I get emails for people wanting to be in person. That's why tonight we have the room downstairs open, is because we've had requests. So, yeah.
It feels difficult. It feels like a burden, but I know we're all trying to get back to normal finally. So I'm on board with the little whining.
As long as I can have my laptop up at the same time to look through stuff.
Yeah.
Absolutely.
Yeah.
I've had my laptop, my binder, and an iPad before there.
Yeah, just making sure. 'Cause for like, I was on code enforcement, it was like less necessary, but for this, I was like, there's no way I could like go through all of this at the same time, just flipping pages.
What are your thoughts on going earlier? That was another question. We had talked before COVID of starting the meetings at 6:30 or 6. Is that a burden on you guys as well, or?
6 would be hard. 6:30 is okay.
Yeah, I think 6 is hard. Again, I would like to pose this to the group via email because we have members that are not present. I can tell you that I would just have to plan to work from home that day.
Oh, Randy's gonna go along with everything.
Well, hey, Randy.
Yeah, I think 6:30 would be easier. I think it's hard if I'm in the office to get back down here in time, but I can make it work. I just don't get to come home and see my family first.
Don't they? I thought they called into the meetings. So
They
could
do
see.
most of the
See?
time, but I don't get to see them.
If you need to have your kids starting to make comments, and then we can.
Yeah.
All right.
We'll do a poll and check with the city attorney.
Perfect.
On all that. Yeah.
City attorney's choice. Do we have anything?
Nothing for me.
All right. Board's choice. I got nothing. Thank you guys for the work you do. Sorry about, I try not to comment sometimes, but I also can't help myself about, because I think the nice thing about part of our board is I think we do have the chance to educate.
Yeah.
So I think that we need to take that opportunity.
Part of maintaining order, right? Like
it's
the quorum.
Yep.
Part of your role.
I think that sometimes it's good to have a two-way conversation with that.
We even had a switch flip.
I wasn't called any names this time. I've only been called names once. And I think that was the board as a whole. So it wasn't just me from what I remember.
It's brave of you, Tom, and I appreciate it though. Sometimes I'm like, he's stepping off a cliff.
Anyway, I really appreciate everyone donating their time. It will be fun to get back together a little, although I think the bar that was located down below that we would have a beer at occasionally has moved. So we would have to find another place.
Oh,
I know.
And that first one's on you, right? I believe.
Yeah.
It should be, at least. All right. So thank you guys so much. Again, sorry about the long meeting. We will see you in perhaps 2 months, not a week.
Yes, sir.
All right. Thanks, guys. See ya.
Thank you.